All right, a quick video on setting up a lifetime trust and some of the tax planning that you want to think about when you're setting up a lifetime trust. So when you're setting up a lifetime trust, there's two general categories. You have revocable and irrevocable. Revocable, meaning the person who set up the trust can revoke or amend the trust at any time. Perhaps that person can delegate certain authorities to other people to be able to amend or revoke the trust at any time. But it's this idea that the person setting up the trust has complete control over it, can do anything he or she wants with it during his or her lifetime. On the opposite spectrum, you have the irrevocable trust, where the person setting up the trust does not contain control over the trust and cannot just simply amend or revoke the trust at whim. Perhaps there's other people who may have certain authorities, but the person setting up the trust intends for the trust to be irrevocable to the extent that he or she cannot simply, on any given day, just say, me by myself, I'm going to make some amendments or changes or revoke the trust. Not allowed. And because of that, that's why the irrevocable trust has certain benefits to it. But getting back to the tax planning opportunities. So very simply, just to keep this video short and sweet, when you're setting up the lifetime trust and you have that revocable or irrevocable option, you're thinking about who's filing income tax returns and who's paying income taxes. For the revocable trust, keeping things very simple here, where we have one person setting up the revocable trust, that person is going to be responsible for picking up any income tax filings and then paying any income taxes due. Versus the irrevocable trust, where it could be either the person setting up the trust or have the trust itself obtain a separate tax ID number and then have all the filings and taxes paid through the trust. So that's going to be analyzed when you're setting up the trust as far as which one of those is the better version, considering your circumstances and what you want out of the trust and out of all of your estate planning matters. Now, when we move along in regard to the life cycle of the trust, keeping it simple again, let's say the person who set up the trust passes. Now, we can no longer have that person use his or her Social Security number to pick up any income tax consequences. That is not allowed. So we would have to obtain a tax ID number at that point. Versus the irrevocable trust, where the decision has been made to obtain a separate tax ID number during life, well, we already have that tax ID number. When the person passes, we do not have to do that at that point. We still have the trust picking up any income tax return filings that are due and paying any income taxes that are due. Now, to put fancy terms on it, the revocable trust, you have grantor trust tax status. And the irrevocable trust that obtains the EIN number or the tax ID number during the person's life is non-grantor trust tax status. However, when the person setting up the trust passes, we change from the grantor trust tax status to the non-grantor trust tax status in that revocable trust. When we have the irrevocable trust that has already obtained the tax ID number during the person's life, when they pass, we already have the tax ID number. There's no change there. We started off as non-grantor trust tax status. We continue along with non-grantor trust tax status. Now, when you go back to the person's life in that revocable trust and using his or her Social Security number, it's really like there is no difference as far as income tax returns, income tax return filings, and income taxes due. Everything is just run through the Social Security number, and it feels like really there's no changes. However, when we do move to that non-grantor trust tax status, then there could be a need to get income out to beneficiaries because we'll get an income tax deduction in the fiduciary trust tax returns. This idea of having income trapped at the trust taxation rates is not desired for most people. Most people would like the income tax to be passed out to the beneficiaries to receive K-1s to report on their income tax returns. And that is how we can still get the income tax bracket management by having the distribution out to those beneficiaries, which is why we go back to the planning end of things. What does the trust agreement state in regard to when the trust may be non-grantor trust tax status? And this could be during the person's life. If you think back to what I said, we could have the person amend or revoke the trust, or could have another person perhaps amend or revoke the trust. And maybe even I set up a new trust. Perhaps there's a need to change gears as far as the overall estate planning matters. And somebody is going to say, you know what? I have this authority now to revoke the trust. And I have this other authority, let's say through a power of attorney or otherwise, to set up a new trust. I'm going to go ahead and do that. Or perhaps there's an amendment to the trust. There could be all kind of sneaky situations where we started off as grantor trust tax status, but we've moved to non-grantor trust tax status. We want that income tax bracket management where we're able to distribute income out to beneficiaries because we still want to use the personal income tax return rates instead of the trust tax return rates. And then when the person passes, we still want to be able to have that kind of play. What does this all mean? Well, it means at the planning stage, we're thinking about distributions of income. What does the trust agreement state in regard to distributing income? If there is a distribution requirement, meaning there's language that says income must be distributed, or income shall be distributed, then the trustee is going to be charged with the duty of distributing that income to the person, the beneficiary in the trust agreement. And that person is going to have to report the income in his or her personal income tax returns. And the trust will get that income tax deduction for the distribution of the income out to the beneficiary. Can get a little complicated when you think about it, because you can have people who may not actually want to receive that income and may not actually be doing what's necessary under the circumstances. Or you could have a trustee who's not getting the income out. They're not doing the right thing. But that's the general idea. Now, we really want to think about capital gains when it comes to potential distributions to beneficiaries, because capital gains are not part of what's called the D&I computation, where we don't have to, and we can't, distribute D&I in the ordinary course of general income principles. It's not considered income in the D&I calculation, which means that we can't get that income tax deduction. And that means that we could have capital gains that are taxed at the trust tax income tax rate, even if a beneficiary is receiving certain distributions that are, stemming from the capital gains. So we want to think about capital gains even at the planning stage, because we want that trustee to be able to potentially make the capital gains part of the D&I calculation more easily. There are other ways to do it, but not the best. We want to actually think about this in the trust agreement itself. And even if we have a revocable trust, because that revocable trust could transfer or transition into potentially non-grantor trust tax status even during the person's life, and will transfer to non-grantor trust tax status at the person's death. Now, ideally, we have a trust that's thinking of all these things, because the trust has, I always say, has some legs to it. It's not that we want this trust to be done as soon as possible, let's say when the person passes, have everything distributed out. And I say ideally because we're really thinking about these things for a longer term matter. We want to put some thought and emphasis into this because we know that trust could be ongoing for some period of time. And because of that, we want to think of these ideas. But even let's say if the trust is supposed to close up shop relatively soon after the person's passing, there could be reasons why it can't, or reasons why the trustee has to keep it going for one reason or another, or just there's going to be a sale of an asset, relatively soon after the person passed, whether there's short-term capital gains or long-term capital gains, and we still could consider this as a potential factor. So getting back to where I started, we're setting up a lifetime trust. We have a revocable trust or an irrevocable trust. We're thinking about taxes during the person's life, and we're also thinking about taxes after the person passes. Now, one thing I do want to state is that there's so many benefits that we can achieve by setting up a trust in regard to those income tax consequences during the person's life. Those are such great planning opportunities, they cannot be taken lightly. So I just want people to know that taxes are, of course, a concern, but there's great benefits to setting up a trust and being able to use that grantor trust tax status during the person's life. And let's say you have assets that pass through an estate when you pass. Those assets are going to go through the process of probate, or surrogate's court has to move those assets out through the whole process and get the assets out to beneficiaries. And that requires a tax ID number. We have to function off a separate taxpayer ID number at that point. When we have a person who passes and assets are in their name alone, in order to get those assets out to appropriate people, then we have this estate. This estate opens up with surrogate's court involvement, and eventually we have assets that are transferred or sold. But we need, at that point, that separate tax ID number, and we still need fiduciary income tax return filings. It's just that they are estate returns as opposed to trust returns. So some people hear trust and they hear taxes and they hear some of the things that I'm talking about and really just turn off the opportunities because they think that this is just too burdensome. And I think that people just need to know that some of these things are done, or we have a trust that's set up during life because we have great benefits from it. And then as well, we don't always avoid these things in any event. When we set up wills and things like that, and we have an estate, and these things don't just go away. We still have things to do. It's just maybe in a different way, in a different manner. All right, so this is my attempt to get some things out quickly today. This is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only, and I look forward to seeing you on another video.